equality, that is from Article 14 to Article 18. In this class we will discuss a right to freedom, that is Article 19 to Article 22. A right to freedom is of tremendous significance in the democratic fabric of our country. With this significance of personal liberty, it occupies the most important place in the list of fundamental rights. This right consists of 4 articles. They are: the right to freedom is of tremendous significance in the democratic fabric of our country. With the guarantee of personal liberties, it occupies the most important place in the list of fundamental rights. This right consists of 4 articles. They are: freedom of speech and expression under Article 19, protection against conviction under Article 20, protection of life and personal liberty under Article 21, protection against arrest and detention under Article 22. Now let us we will discuss freedom of speech and expression, which is guaranteed under Article 19. Article 19 protects the 6 valuable freedoms. That means all the citizens shall have the right. A right to freedom of speech and expression guaranteed under Article 19(1)(a), right to assemble peacefully and right to assemble peacefully and without arms guaranteed under Article 19(1)(b), right to form association and unions guaranteed under Article 19(1)(c), right to move freely throughout the territory of India guaranteed under Article 19(1)(d), right to reside and settle in any part of the territory of India guaranteed right under Article 19(1)(e), freedom of right to practice any profession or to carry any occupation, trade or business guaranteed under Article 19(1)(g). Article 19(1)(f), freedom to acquire, hold and dispose of property, was deleted by Constitutional Amendment Act, as a result of which citizens enjoy only 6 freedoms, whereas earlier citizens enjoyed 7 freedoms. Let us discuss one by one. Article 19(1)(a) guarantees freedom of speech and expression. That means a citizen in India can speak freely and give full expression of his choice and thought concerning any subject. He can speak to anyone and address a group of people. He may put his thought according to his choice on paper, meaning he can express his opinion either by writing books or articles in newspaper and magazines. He may freely speak on political affairs and may criticize government for its act of commission or omission. The freedom of press is an essential condition of democracy, but this right is not specifically mentioned in the Constitution. The freedom of press is implied in the clause 1(a) of the Article 19. Freedom of speech applies only to citizens. No citizens cannot claim rights under Article 19, since the freedom of press is only the incident of freedom of speech and expression. Therefore, a foreigner running a newspaper cannot claim the freedom of press as a fundamental right. But however, he may claim it is an ordinary legal right. In a number of cases, the Supreme Court has applied the freedom of press is implied in the freedom of speech and expression. For example, in Eastern Newspaper versus Union of India, the right to freedom of speech and expression is not absolute. That means it is subjected to reasonable restrictions as laid down in the Clause 2 of Article 19. It should not go against the security of the state, friendly relations with foreign state, and it should not disturb the peace and public order. It should not violate the accepted principles of decency and morality, and it should not go against the court order, or it should not commit the contempt of court or parliament, defame or provoke and incite the people to commit crime. The next one is Article 19(1)(b), guarantees the right to assemble peacefully without arms. Freedom of speech and expression is meaningless in the absence of right to assemble or hold meetings for discussion. Democracy is based on peaceful discussion. Therefore, it is made clear that those who hold meetings shall bear no arms. The right to assemble peacefully and without arms is subject to reasonable restrictions. The right shall not affect the operation of any existing laws as far as it imposes restriction in the interest of sovereignty and integrity of India or public order or morality. The next right is guaranteed under Article 19(1)(c) is right to form association and unions. Literary groups, cultural association, sports club, trade unions, religious associations and religious types of other association may be formed and function freely with their aims and activities is not against laws. This right can be restricted by the state in the interest of preserving the sovereignty and integrity of India or public order and morality. The next right is Article 19(1)(d). It guarantees the right to move freely throughout territory of India. No legislature can pass laws arbitrarily restricting the movement of citizens from one state to another and from one place to another. This right is subject to restrictions as laid down in the Clause 5 of the Article 90. This right does not prevent the state from making any law imposing reasonable restrictions either in the interest of general public or for the protection of interest of any scheduled tribes. The next right is Article 19(1)(e) guarantees a right to reside and settle in any part of territory of India. No legislature can pass the law compelling a citizen to reside or settle at a place against his will. This right is also subject to reasonable restrictions as given in the Clause 5 of Article 90. The next right is guaranteed under Article 19(1)(g), a right to practice any profession or to carry out any occupation, trade or business of his choice. No legislature can pass laws arbitrarily compelling a citizen to follow any profession against to his will. The six fundamental rights guaranteed under Article 19 are automatically suspended. Article 19 is automatically revived after the expiry of national emergency. Article 359 enables the President to suspend the fundamental rights guaranteed under the Part 3rd of Indian Constitution except Articles 20 and 21 during national emergency. The next freedom of right guaranteed under Article 20 is protection against conviction. Article 20, Clause 1 says that no person shall be convicted of any offence except for the violation of law in force at the time of commission of the act charged as an offence, nor subjected to a greater penalty than that which might have been inflicted under the law in force at the time of commission of the offence. No person shall be prosecuted and punished for the same offence more than once. No person accused of an offence shall be compelled to give a witness against himself. This article is applicable to all persons and not only a citizens. Let us discuss the Article 20, Clause 1, Clause 2, Clause 3, one by one. Clause 1 of Article 20 makes it clear that there shall be no ex post facto legislation in India. That means Indian Constitution prohibited the ex post facto law because it imposes the penalties or punishment retrospectively. An ex post facto law is a law provides that no person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act. If any action done which was innocent at the time of commission of the act, after passing the law, it forbidden the particular act, then this law cannot be applied to those who committed or done action before this law come into force and not subjected to a penalty greater than that prescribed by the law in force at the time of commission of the act. For example, the Dowry Prohibition Act 1961 came into force on 20th May 1961. A person guilty of accepting dowry is punishable under this act after this law come into force only, not those who are taken the dowry before this enactment came into force. The next one is double jeopardy. Under Article 20, Clause 2, no double jeopardy means no person shall be prosecuted and punished for the same offence more than once. The protection against double jeopardy is available only in proceedings before a court of law or a judicial tribunal. In other words, it is not available in proceedings before departmental or administrative authorities as they are not judicial nature. A recent judgment in State of Mizoram versus Dr. C. Sangongina, Supreme Court held that the bar of double jeopardy will not apply if the person was discharged due to lack of evidence. In this judgment, Supreme Court held that where the accused has not been tried at all because of lack of evidence and convicted or acquitted, the principles of double jeopardy cannot be invoked at all. The expression self-incrimination means a person shall not be asked to make statement against himself, that is self-harming statement or confession statement. The Indian Constitution under Article 20 Clause 3 provides immunity to the accused against self-incrimination. Article 20 Clause 3 prohibits self-incrimination. That means it says that no person accused of any offence shall be compelled to be a witness against himself. No person is bound to give any witness a statement against himself which make him accused. Using of narco-analysis technique amounts to testimonial compulsion and thereby triggers the protection of Article 20, Clause 3 of the Constitution. The next right to freedom guaranteed under Article 21 is protection of life and personal liberty. Article 21 says no person shall be deprived of life or personal liberty except according to a procedure established by law. In the phrase procedure established by law, the word law was interpreted to mean a state-made law and not a law arising out of rule of natural justice. In the famous case A.K. Gopalan versus State of Madras, Supreme Court has taken a narrow interpretation of Article 21 and it held that protection under Article 21 is available only against arbitrary executive action, not from arbitrary legislative action. This means that state can deprive the right to life and personal liberty of a person based on a law. In the same case, it maintained the personal liberty means freedom from physical restraint of a person by imprisonment. But in Maneka Gandhi versus Union of India, Supreme Court overruled its earlier decision by taking wider interpretation and held that the right to life and personal liberty of a person can be deprived by a law provided the procedure prescribed by the law must be reasonable, fair and just. Article 21 stands against arbitrary executive action as well as arbitrary legislative action. The right to life in Article 21 of Indian Constitution does not mean animal existence or mere act of breathing. It guarantees a right to dignified life. Following some of rights that are currently included in the ambit of Article 21. They are a right to live with human dignity, a right to decent environment including pollution-free water and air, and protection against hazardous industries. A right to livelihood, a right to privacy, a right to shelter, a right to health, a right to free education up to 14 years of age, a right to free legal aid, a right against solitary confinement, a right to speedy trial, right against handcuffing, right against inhuman treatment, right against delayed execution, right to travel abroad, right against bonded labor, right against custodial harassment, right to emergency medical aid, a right to timely medical treatment in a government hospital, a right of appeal from a judgment of conviction, a right to social security and protection of the family, a right to social and economic justice and empowerment, right against bar filters, right to appropriate life insurance policy, right to sleep, right to freedom from noise pollution, and finally right to electricity. The right to freedom guaranteed under Article 22, that is safeguards against arbitrary arrest and detention. Article 22 constituted within the right to freedom. This article is covered in two major parts: protection and rights granted in case of arbitrary arrest, also known as punitive detention, and safeguards against preventive detention. The main difference in that whether a person is charged with a crime or not. In case of detention, the person is not accused of any crime, but he is restricted on a reasonable suspicion, while in case of arrest, the person is charged for a crime. These articles also prescribe the procedure to be followed when a person has been arrested and held in custody without trial. It mentioned the following points. No person who is arrested shall be detained in custody without being informed as soon as may be the grounds of his arrest. No person shall be denied the right to consult and be defended by the legal practitioner of his choice. Every person who is arrested and detained in custody shall be produced before the nearest magistrate within the period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of magistrate, and no such person shall be detained in the custody beyond the said period without the authority of a magistrate. Dear student, you should aware of it. Nothing in class 1 and 2 shall apply to any person who is arrested or detained any law providing for preventive detention. Preventive detention means to detain a person to prevent that person from committing any possible crime, or in other words, preventive detention is an action taken by the administrative authority on the grounds of suspicion that some wrong action may be done by the person concerned, which will be prejudicial to the state. If the person who has been arrested or detained under preventive detention laws, then protection against arrest and detention provided under Article 22 Class 1 and Class 2 shall not be available to that person. That means under Class 4 of Article 22, no person providing for preventive detention shall authorize the detention of a person for a longer period than 3 months unless the opinion of the advisory authority. That means under Article 22 Class 4, no law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months unless produced before the advisory board. A detained individual should be made aware of the grounds of detention and shall provide an opportunity of making representation against the case or against his detention. I want to point out some of the preventive detention laws in India, that too after independence. After gaining an independence, the first preventive detention law is Preventive Detention Act 1950. It was initially effective for 1 year but was allowed to continue till 1969. Its validity was upheld by the Supreme Court in the famous case, that is A.K. Gopalan versus State of Madras. This case is also known as India's first fundamental rights case. Since then, India has periodically enacted various such laws. One of the most prominent among them is Maintenance of Internal Security Act 1971, that is MISA. MISA is infamous for its use during the emergency period in the 1970s, particularly in the year of 1975 to 77, to arrest opposition party leaders. MISA remained effective till 1978. 2 years later, the National Security Act 1980 was enacted, which continues to be effective till the date. Therefore, barring of 2 short periods of 1970 and 71 and 1978 and 80, India has always least one preventive detention law in place. I hope the student you understood the concept of right to freedom, which is guaranteed under Part 3rd of Indian Constitution, that is under Article 19 to 22. That is right to freedom of speech and expression, right to assemble, right to association, right against arbitrary arrest, and right to personal liberty. Thank you.